Chapter 15, Legality and Public Policy. Do you want to order a contract killing, Don Carlos, or a pay-as-you-go killing? Wow. So what are we talking about here? We're continuing to look at our elements of the contract. We started with an agreement. When we have an offer that's validly accepted unconditionally, we have an agreement. That agreement must be between competent parties who express genuine assent, who've exchanged consideration, and the contract must be for a lawful purpose. When Don Carlos is being asked, do you want a pay-as-you-go killing, or is he going to pay up front? You've got a potential agreement, a potential contract, but the issue is that for a lawful purpose? A contract will be considered an unenforceable agreement if it falls into one of three categories. If the contract's formation is for the performance of a crime. If the contract, remember K stands for contract, if the contract is contrary to public policy, or if you could categorize the contract as being unconscionable. Like unconscionable we'll talk about is if it's just it's a bad thing, it goes against our morals and we think it's wrong and grossly unfair. We'll look at these in turn. The first category of unenforceable agreements is pretty straightforward, and we're all familiar with this one. If the contract is illegal. If the contract on its face is illegal, it's going to be void. That means that neither party can enforce the contract, neither of them can sue if the other party fails to perform their part of the contract. And even if the contract appears to be legal when it was created, it could be considered unenforceable if we can determine that the contract was entered for an illegal purpose. For instance, you may recall a couple of years ago, the actor Jussie Smollett, and there was some question about whether or not he had paid his, I think the man was his former workout instructor or trainer, and he paid him to stage a false beating. Now, putting aside whether or not you agree with what happened there, if you agree that that he had staged it, on the face of the contract, possibly he offered to pay the trainer $200 and the trainer agreed. And without knowing more, that might appear to be a valid contract. But if we can come up with facts that realize actually that payment of $200 was to stage a crime, even if it wasn't said up front, if we can determine that that's what it was about through other facts, then that contract could be unenforceable. So if, for instance, Jussie didn't pay the $200 and the trainer reports it to the police, and Jussie says, oh no, that was $200 for a workout, and the trainer says, no, actually it was for me to beat him up, and if he could prove it, then even though that contract appeared to be illegal on its face, it would be illegal because of the purpose. The general rule is that contracts that are illegal for a commission of a crime or for an illegal purpose are void. They will not be enforceable in court. A criminal act is like our earlier example. If someone, a man contracts with a hitman to take out his wife or take out an adversary, we all kind of recognize that as a classic illegal contract to commit a crime. Another context, let's say a lobby group offers a politician money for that politician's vote on laws coming up that affect their industry. That's also illegal. That also happens. That is an unenforceable contract. If the politician took the money but then didn't vote the way that the lobbyist had asked, that contract would not be enforceable. The lobbying group would not be able to take the politician to court and say, hey, what happened to our vote? We already paid you. And unfortunately, in our society, most of the time the politician does what they were asked to do and takes the money. So there's no enforceability issues because they are following through with their end of the deal. But let's say they didn't. What would the lobbyists be able to do? They couldn't enforce the contract. So usually what do? They expose the politician. And that's oftentimes why we hear about the bad acts of politicians. If they, tick off somebody that they made a promise to or was, dealing negative in bad faith with, really the only recourse for people who are entering into those illegal transactions with politicians or people in government is to expose them, because they can't get their money back. They can't enforce whatever their illegal contract was. So they must expose them. All right. So those are examples of a criminal and civil illegal contract. In general, neither party can enforce such a contract. But as always with the law, sometimes we have exceptions. There are exceptions if we're trying to protect one of the parties. In other words, even though the parties may have entered into an illegal contract, sometimes the courts, in order to avoid hardship, will make an exception if the parties are in unequal guilt, like they're not guilty to the same extent. They're, one may be an innocent party. A good example of this might be if we had an illegal contract and one of the parties was a minor. Remember, the minors can get out of the contract, even though they lied, misrepresented their age, and the contract is illegal because they technically don't have the ability to enter into contracts. That is an exception in the law where we're protecting the party that we think needs protection and is not quite as guilty as the other. Sometimes we have contracts and we could argue that only a portion of the contract is illegal. So if we can look at the contract and point out to the court that parts of it are fine or are enforceable and that the illegal portions are divisible and can be separated from the rest of the contract, then we could ask the court to enforce the good parts or the valid parts and then just not enforce the illegal portions. So how do we do that? One of the main ways to make it easier to enforce portions of a contract when other parts are unenforceable is to make sure when you are drafting your contract that you put it in divisible, identifiable paragraphs. If you were to pull out your lease, you would notice that each issue, each topic has its own provision. It might be by Roman numerals, like you might have 1, 2, and 3, and then under section 2, you've got parts A, B, and C, and then it might say, C, 3D for information about when the rent is due. Why do we put those divisions in the contract? It's not just to be well organized. Some of it is about being organized and having a contract. But if you put your contract obligations in separate sections that are identifiable, if in one section, let's say 4A, turns out to be something that's illegal and that's no longer permissible under the law, then 4A could just be stricken or not enforced. And then the remaining paragraphs, because they have been separated in the contract, would be enforceable. So this is a main tool that lawyers use when we are preparing contracts. When I prepare a contract, I would never just write it in one long continuous paragraph from page 1 to 2. I wouldn't even write just paragraphs. When you think about an essay, you might have a 5-paragraph essay. I would never do that in a contract, because a 5-paragraph essay type contract is just one big contract and none of it is going to be divisible. And so if there's a problem within any paragraph, it's all going to be read together and then the whole contract would be void. So if I had 5 issues, 5 topics I'm covering in a contract, I'm going to designate them section 1, 2, 3, 4, and 5, and I'm going to have subsections there underneath those to make every piece of it divisible in case there's a problem. Again, the main category of contracts that are illegal are those that are put together purposely to commit a crime or commit a civil wrong. A crime is illegal, and therefore, whatever contract the parties put together to commit the crime is going to be void. It won't be enforceable against either party. And, of course, both parties could be sent to jail. An agreement that calls for the commission of a civil tort is also illegal. The civil tort is like the example I gave earlier, when you bribe a government official to do something, and maybe you're bribing them to get their vote. That is a civil tort. They're not committing, they're not hurting anybody, although arguably they're hurting society. That is going to be illegal and unenforceable. What are unconscionable clauses? What are unconscionable contracts? That was the third category I listed in our first slide. A contract that contains an unconscionable clause or provision could also be deemed unenforceable. A court could hold a contract unenforceable if there's a provision in it that is just so bad that we're like, it's without conscience. It just shocks so the morals of your regular person. And what does that mean? It's hard to give you all the examples. This is sort of a catch-all category for contracts where we don't know, we don't have a laundry list going into it of what it might be, but it's going to be on a case-by-case situation. The court looks at two things: clauses that give too much of an advantage to one party, or clauses that are too harsh or oppressive. For instance, you may have seen companies that give like payday loans, and they give people access to money who are in bad situations on short notice, but in exchange, there's sort of a loan on their future proceeds. Well, sometimes those contracts in those pay advance loan situations have been considered unconscionable if the interest rate being charged was extremely high, or 3 or 4 times what the average market rate is. When you're looking at unconscionable clauses within a contract, you're looking for a situation where one party is grossly taking advantage of the other because they are in a superior bargaining position, and so they give the other person terms that nobody would normally agree to, but they have nonetheless agreed to it because they're desperate, or they weren't able to, they knew they couldn't get the deal without agreeing to it. And that's why those early payday contracts are a prime example, because obviously if you're going to a company trying to get an advance on your paycheck, you're probably in a tough financial situation, and you're willing to do whatever terms are presented to you in order to get the money now. And some of those businesses put in extremely egregious interest rate return, interest rates on the loan, and those can be considered unconscionable. This type of unconscionable clause that I've been talking about is sometimes referred to as procedural unconscionability. It relates to a huge difference in bargaining power. If the party you're entering into a contract with has all of the power in the relationship, like they can set the terms and there's really nothing you could do about it if you want to get what they're offering, then sometimes they'll put provisions in the contract that it's like on a take it or leave it basis, and you really don't have a choice. And you might go ahead and agree to it, and if it's really egregious, you might be able to argue later that that contract was unconscionable because they took advantage of you. It was grossly unfair, and therefore, court, even though I agreed to repay that loan at 28% interest, please don't make me have to, don't enforce it because they took advantage of me. That's the way this argument is working. This is in contrast to substantive unconscionability. This is when the terms of the contract are considered so egregious, so shocking, that the regular average person would be stunned if they heard that you were required to do what? Now, this example, and I'm giving that example because there is no definition in the law as to what equals unconscionable exactly. You would look through case law and see in previous circumstances, what did the court find to be unconscionable? So that's why this is really murky here, and you might be scratching your head and saying, you're not giving me any real examples. Well, unconscionability is something that you would look at on the face of the case, and it's an argument that you make if you thought what happened was just horrible and was grossly unfair. So one example that I'll give you that I have done with previous like work problems when we were in class is, let's say you have a telemarketer. They call an elderly woman on the phone and they offer her pots, and they're trying to get her to purchase the pots, and they got her to enter into a contract to buy the pots for $1,000. Now I'm talking about pots people use to cook food in. And the telemarketer talks the lady into purchasing the pots over the phone, and she agrees to the $1,000 pots. They made an offer to sell pots for $1,000. She accepted the offer. They've got a valid contract. And that's a contract that on its face is not illegal. It's not illegal to sell products for more than they are worth. And let's say the pots are really only worth $100, but they got the elderly lady to purchase them for $1,000. That on its face is not illegal. Businesses selling things for more than they're worth, pushing up the price, is perfectly legal in our capitalist society. We as buyers or purchasers, it's on us to decide, are we willing to pay that much for a good? So typically in capitalist economies, we don't limit what kind of price they put on it. The market is supposed to set the price. If you put your pots on sale for $1,000 and nobody buys them, well, then you know $1,000 isn't going to work. But if you find a couple of gullible people who are willing to pay $1,000 and they do it, then the seller is happy, and that's legal under our system. Unless we have other facts that make it seem like maybe it's illegal, like unconscionability. In the scenario I just gave you, if you've got someone who's elderly who purchased the pots for $1,000, and then let's say her niece or nephew, which would be you guys, you find out about, that your great aunt was taken advantage of, and you say, I don't think you should have to pay this, even though you agreed to it. This seems unconscionable. This seems grossly unfair. This is wrong. You were taken advantage of. Well, how would you prove that? Most marketing calls are recorded. You get an attorney, you send out discovery. Remember our discovery request? You get request recordings or any transcripts made of the call. And lo and behold, when you get the transcript of the call, you see that great aunt, first of all, couldn't really hear what it was they were saying. She didn't know who she was speaking with. She thought she was getting possibly more than what they said. Maybe she thought she was getting 1,000-piece set of pots for $1,000, or whatever the facts may be. You would use evidence like that to show, wait a minute, you took advantage of her. You had an old lady on the phone call whom you knew couldn't really clearly understand what you were offering, and she agreed to give you her credit card number over the phone without knowing what she was doing. If you had facts like that, you could go to court and argue, even though it's a valid contract on its face, it was unconscionable because the terms to get somebody on a fixed income to pay $1,000 for goods that are only worth 100 is unconscionable. That's how that argument works, right? I gave you a long example for you to see unconscionability is a tool to use to invalidate an otherwise valid contract. You're saying, yeah, this is illegal on its face, but if you look at the actual circumstances here, this was wrong, like grossly wrong, and it would be unfair to hold my client to this contract. Third category of contracts that courts sometimes will not enforce is when you have an agreement that is said to be contrary to public policy. In this scenario, you have a contract that on its face appears to be legal. However, the contract calls for something that one of the parties is saying or arguing it's so offensive to society that it should not be enforced. And therefore, the party who's trying to get out of the contract, who doesn't want to have it enforced, would go to court and argue, yes, this is technically legal. They made an offer and I agreed to it. But what is in this contract is morally offensive and contrary to public policy, our grouply held morals, what most people would think is right to do. And therefore, court, do not enforce this contract. Don't make me do what I otherwise agreed to do. This is a really tricky way to try and get out of a contract, because public policy and what is public policy a lot of times has to do with the time and history that you're looking at. What we think is right, just, and moral today is different than it was when the Constitution was created, or different than it was perhaps 50 years ago, maybe even 20 years ago, depending upon the topic. Your view of what morals are actually grouply held can differ based upon your political affiliation, your view of the Constitution, your background. The judge, as we've talked about before, the Ninth Circuit Court of Appeals is generally held to be the most progressive in the United States, whereas the Fourth Circuit that we are in, the Sixth Circuit out of Georgia, are considered to be appeals courts that are very conservative in their view of social issues. And therefore, judges on those respective benches, Ninth Circuit, say, versus Sixth Circuit, may have a very different view of what they believe public morals are. So a public policy argument can be really tough to make. And it's a way to try to invalidate an otherwise legal contract. So you may be thinking, well, what is an example of this? One modern day example that you've probably heard of is a gay couple ordered a wedding cake from a baker, from a bakery, and the baker refused to make the cake because she said it was against her religious beliefs. Now, there are lots of issues in that case, and I'm just going to use this as an example. I'm not sure that they argued public policy in this case, but let's just, this is a good fact scenario that would kind of fit our public policy argument. One could argue if the people getting married had called the bakery up, placed the order, and the baker had accepted the order, not knowing what context the cake was going to be used in. They just agreed to it. There'd be a binding contract to make the cake. All right, let's assume that happened. But then later, one of the parties to the engagement showed up at the bakery and started giving the baker the details of what they wanted the cake, and maybe they asked, for same gender people to be put on the top of the cake, such that the baker then realized what the context was. And then they decided, oh, I'm not going to make this cake. Yes, I already took your deposit and we have a binding contract, but I don't want to do it. All right. So the couple who had entered into the contract would reasonably want to enforce the contract. And let's say the baker might make a public policy argument, and depending upon where they were located, will depend upon how far this argument could go, right? The bakery might argue, well, we entered into a valid contract, but we think it's against public policy to make a cake for this kind of context. If they're in the Ninth Circuit, which in this fact scenario they were, that's probably not going to work, because in that circuit you've got judges who are more progressive and realize that they acknowledge the sanctity of marriage for all people and not any preset people. If that case had come up in, say, the Sixth Circuit or some very more conservative jurisdiction, maybe even Fourth Circuit where we're located, that there may have been judges who would have thought as a public policy argument that the bakery is right. They agreed to make the cake not knowing what it was for, and it's against their morals, and so we will allow them to be excused from their obligation. So that is a modern day, not fun, but modern day example of how either side could try and use a public policy argument to get out of an otherwise binding agreement. The baker in this context is trying to argue that they believe it's against public policy to have to make a wedding cake for a gay couple. But you could see that the other side would say, well, wait a minute, now that's against public policy to be discriminatory. And then the issue is, well, where do we stand on this as public policy, which is kind of an ongoing issue. But that is a current example of how you could have a legal contract, binding contract, but one side try to get out of it and claim that they think it is offensive to have to actually comply with the agreement. Gambling. Gambling contracts per se are illegal. There have been exceptions carved out in states to run state-run lotteries, and also on Indian reservations at times, and different communities sometimes apply to be able to run certain kinds of games. But generally, lotteries, gambling, wagering is considered illegal. License callings or dealings. What is this category talking about? If you operate in a profession where it is required that you have a license in order to hold yourself out to the public, if you don't have that license and you enter into a contract with someone, for instance, if you hold yourself out as a lawyer and you actually haven't passed the bar exam, and you do legal work for someone and they promise to pay you, so you enter a binding contract, you win the case for them. If that individual finds out you're not licensed to practice law, they don't have to pay you. Even if you won the case, even if you put it in writing that they would pay you, say, $1,000 for your representation, that contract would be illegal because that the professional did not have the license that they were required to have. And this is the case with many professions, stylists, barbers, real estate agents. If you are operating in a profession that by law requires that you have taken a test, that you have a license that authorizes you to operate in your area, that law is designed to protect the public. And even if you enter into a contract with someone who knows that you are not licensed and you do a good job, they could refuse to pay you because that contract would be unenforceable, because it would be illegal. This protection is similar to our minors. Remember, we talked about minors can enter into a contract. They can misrepresent their age with you if you're the adult, and they still are able to get out of the contract. This is a similar, and that's to protect the minor. Similarly, the public is being protected here. If you go to a builder who lacks the proper authorization, doesn't have his license to do work, you agree to pay him and he does the work, you could get out of the contract. Now, we do have something called quantum merit, where that person might be able to, if they've done substantial amount of work, they could ask the court to award them out of sense of out of fairness, to at least reimburse them for their out-of-pocket cost, but they won't be able to make their profit. But with lawyers and doctors, because sometimes doctors have been sued for malpractice, not actually having the license that they said that they had. In those situations, you're likely not even going to get any money for out-of-pocket expenses. The contract is just going to be illegal. Contracts in restraint of trade. Recall when we talked about the Sherman Act earlier, that the general rule is that individuals and businesses cannot set up, enter into contracts, combinations, or conspiracies, or dominate the market in a way that makes other competitors unable to compete with them. They're not supposed to unreasonably restrain trade. That is illegal, right? They're not supposed to do that. But we make an exception in certain narrow context. Agreements not to compete. If an employer offers you a job, but they are going to be giving you a position or putting you in a position where you would have access to their important or secret business information. You might be, or you have access to their secret sauce, their private customer list, different things that if you were to take that information and leave the company, you could literally take all of their business or ruin them. They have the right, this is an exception under the ability of not restraining trade. An employer can restrain competition with an employee. And so this typically happens is when you're offered the job, you're asked to sign a non-compete agreement. And non-compete agreements are legal so long as they meet the following requirements. First, the restriction that they create must be designed to protect a legitimate business interest, i.e., they've got to be able to point to something specific that they're trying to make sure that you would not compromise. In other words, you have to be in a position to have access to knowledge, information, patents, secret information that they have that would hurt their business if you were to disclose it. And the restriction has to be reasonable as to scope, that means like the geography, and time, how long it lasts. For example, you might be offered a sales position after graduating with a company, and you're going to have the list of companies, of other companies that maybe you call on who are the customers of your employer. And this is really, tightly held information because developing a good customer list and knowing who would buy your product is something that employers want to protect. So when you're offered your position, your sales position, they say that as a condition of this employment, you agree not to compete with the employer for a period of 2 years within the southeast of the United States. So that would be a non-compete that restricts you from, let's say, working for a competitor, because usually that's what's put in there, working for a competitor for 2 years, that's the time, within the Southeast United States. That's your scope. So the scope refers to what geographic location you're not allowed to work in, and the duration refers to the time. The business who's asking you not to compete has got to have a legitimate business interest that they're trying to protect. You must be in a position to have access to that knowledge. And then you may only be restricted from competing for a reasonable time and scope. If any one of those pieces is missing or lacking, then the provision will be considered an illegal restraint of trade and it won't be enforced against the employee. The general rule is that if any element of the non-compete is unreasonable or lacking, then the non-compete would not be upheld against the employee because the contract would be considered an unlawful restraint of trade, and the employee could go out and work for anyone they wanted to, even though they had signed an agreement promising not to. That's if there's a lack of legitimate business interest, the restriction was unreasonable as to time, in other words, it lasted too long, or if it was unreasonable to scope, it took up too much of the United States or their working area. But in some states, the courts follow what's known as the blue pencil rule. In courts that use the blue pencil rule, they have decided that if we have a non-compete that's unreasonable, we can use our proverbial blue pencil, i.e. pull out my pencil, the judge that says, and fix what's unreasonable, make it reasonable, and then enforce it against the employee. For example, let's say you are offered a sales position at your new employer, Texas Instruments, and you head out to Texas. When you're excited because you just graduated from A&T and they offer you a sales position, and as part of the employment contract, they say, we need you to sign a non-compete where you are promising not to work for a competitor anywhere within the Southwestern United States for a period of 5 years. Because it's your first job and you don't want to turn it down, you say, yes, fine, whatever it takes, I want to take the position, right? Because you don't really have a lot of bargaining power, particularly on a first job. So you sign this agreement. Then you work for the company a few years, you gain a lot of information, you're a top salesperson, you know lots of good information about what kind of customers you need to call on to get good sales for your employer. And then you leave. Why? Because you got headhunters at this point who are competitors of Texas Instruments who know that you have this information and they would like to lure you with the promise of more money. Come work for them and deploy your knowledge, which is exactly what that non-compete was saying you wouldn't be able to do. So you leave your employer and then you work for a competitor. It's and a lot of times people think, well, they won't know. Most companies, if they're doing non-competes, they have a system in place to try and make sure that they can find out. And particularly if you're in a really specialized industry, it would be relatively easy for them to ascertain whether or not you are working for a competitor. So let's say that Texas Instruments finds out that you're working for a competitor, and so they move to sue you to enforce their non-compete. You might go to court and say, wait a minute, I don't think this non-compete was reasonable as to the duration. Yes, I had access to customer secrets. They had a legitimate business interest that they're trying to protect. Yes, I'm in the Southwestern United States, which is where they are located. But the non-compete lasts for 5 years. And you might try to argue that's too long. That's a large portion of a person's career. And so you might argue about that, and you will, use case law. And I will tell you that most of the case law says that a reasonable non-compete is about 2 years. An employer can restrict a former employee from working for a competitor on average for about 2 years. Beyond that, they're going to really have to show that in their industry that 2 years is not sufficient, or you had really special knowledge that still would be in play, because typically they're thinking after 2 years, whatever you had, the knowledge you had probably may be stale, or things may have, technology may have evolved, so that after 2 years is just long enough to protect whatever you had access to. If you're in a state that follows the general rule, the fact that the non-compete is for 5 years, which is generally considered a very long time and possibly unreasonable, then the whole non-compete will be stricken and you would be able to violate it, not follow it, and it would not be enforceable. But if you're in a state where the courts follow the blue pencil rule, the judge hearing the case could just fix the unreasonable part. They could say, all right, 5 years is too long. We've heard what Texas Instruments has to say. They've put on evidence of what you had access to. We're going to change the non-compete to last till 3 years. And it's still enforceable. And you owe damages and you need to leave that employer that you're currently with, or whatever else they're going to do. So in jurisdictions that follow the blue pencil rule, the employer gets more protection. Do you see that? because the court will fix a poorly drawn non-compete and enforce it against the employee. So the employee would have to follow the non-compete. In states where the courts don't follow blue pencil rule, if anything is wrong, the whole thing is considered unlawful, illegal, and is not upheld. Now, one thing you may be wondering right now is, should I sign a non-compete? Some of you probably have already been asked to sign them in certain jobs. They're fine to sign. You just need to read how long they're going to last and what the scope is, and make kind of a decision for yourself. Is this reasonable? Maybe you wouldn't even want to stay in the Southwest, for instance, if you had signed the Texas Instruments non-compete I just described. If you're not working for a competitor located in the Southwestern United States, then the non-compete agreement wouldn't apply to you at all, right? Or if you actually don't have access to any business secrets or things at the company, then the non-compete also would not apply to you. So it's fine to sign them. Just make sure you read them carefully and that you are aware of what is required.